Greetings, everyone. I hope that you are doing well. Happy New Year and best wishes for the rest of 2022. I want to welcome you all to the UE Soft and Life Skills Series webinar under the auspices of the UE IAD, and it's our first webinar series for 2022. My name is Tamoy Campbell, and I'll be your moderator for this session. Now, this session is all about estate planning, but estate planning and beyond, and it will be facilitated by none other than legal mind Mrs. Nadine Atkinson-Flowers. Now, I saw that you were all posting in the chat where you're from, so I'm going to ask you to please continue, whether it's from Jamaica, Trinidad, Barbados, wherever it is from, we want to know so we can hail you up and say hi to all our friends who are here gathered in Zoom land. Now, to get into the meat of our discussion, as I said, will be facilitated by Mrs. Nadine Atkinson-Flowers. But of course, we have to know a little bit about who she is. Now, Nadine Atkinson-Flowers is an attorney at law, and she's admitted to practice in the United States of America and in Jamaica. Her United States of America practice is in the area of immigration. Her Jamaican practice areas are criminal law, immigration, estate matters, and general legal consultancy. And she has under her belt 15 years of experience. So you know that you're getting something really top tier and top-notch information. She also focuses on how U.S. immigration matters can be affected by Jamaican law. In her latest book, On Your Feet, Criminal Law Practice in the Parish Courts in Jamaica, it is now available through the publishers of Ian Randall Publishers as well as on Amazon. And we'll also be posting it in the chat and it will be projected on the screen so you can see and check it out. In addition, she has practiced both as a prosecutor and a defense attorney in Jamaica. She does regular legal presentations, just like these, online and in person, on various topics, such as criminal law procedure, criminal practice, and in the parish courts, immigration, the law of business, contracts, disabilities, common legal problems, and ethics. Nadine frequently presents at law conferences and volunteers in several legal, business, children, and community service organizations in Jamaica and in the United States of America. She is the author of several legal publications as well as books on Caribbean history. Nadine frequently writes how-to-dos for persons needing access to the justice system. So should you be in need of any information, Mrs. Nadine Atkinson-Flowers has all the expertise here to share. Now, ladies and gentlemen, my 142 participants from all over the world, please make welcome to the virtual stage or presenter for this session, Mrs. Nadine Atkinson-Flowers. Over to you.
Good night, everybody, and good night or good morning, wherever you are out there in Zoom land, as Tomoy nicely puts it. Thank you very much for the warm welcome, and I hope that the session will be informative and interactive. If you have questions, you can put them in the chat. We're going to do a few polls to keep it fun, and we ask that if you have questions, you put them in and we will see how best we can answer them. Estate planning, beyond your will and last testament. Almost sounds as if it's Star Wars, doesn't it? But the idea is when you're making those plans for that final destination, which unfortunately all of us have to go to. You know, it's a road we all have to walk, all have to travel. There are so many plans that sometimes we actually forget to make. But we want to share with you this evening some tips, some tricks, some ideas, some suggestions as to what you can do to ensure that the whole idea of estate planning is something that does not seem foreign to you. It's something that you can embrace and actually decide, yes, I can do this. You might ask, what is an estate? And really, what is this business of estate planning? Right off the bat, we're going to ask you to answer the first poll that we're going to put up about what is your estate, or what do you think is your estate? You should be seeing the poll very soon. So I'm gonna give it about another minute. I see people are busy typing away. Wow. People are still typing. All right. Now, it seems people are still going at it. Let me give it maybe 10 more seconds. 10, 9, 8, 7, 6, 5, 4, 3, 2, 1. I'm going to end the poll. We have almost all the persons who have answered. Most persons, almost 85% said they figured their estate is money. Understandably so, because that is something quite tangible. 97% though said house, property, land. I was brought up to believe that if you have property, whether it's a house or land, then you have an estate. You have something that you can leave. Some persons, we have 85% persons said investments, and some 72% said clothing, jewelry, and about the same said a car. But what about other types of things that could become part of your estate? What about intellectual property? I'm a writer, and persons who are musicians, persons who are poets, persons who are singers, other persons in the entertainment industry, they have intellectual property that can be left to persons in their family or friends structure when they die. We've been hearing the news, various local artists who have died, and there is quite a bit of activity, I will euphemistically say, regarding their estates. All of that is part and parcel of the estate. There are something that's going on now, NFTs, this whole business, non-fungible tokens, the whole business of the metaverse. All of those are possibly part and parcel that could be part of your estate. What about if you have a business, the goodwill in the business, the property that is in the business, dependent, of course, on how the business is structured. And we'll talk about that a little later. Now, some of you might say, "Me broke, I have none for left to nobody." But as we have seen from this brief survey that we just did, there are lots of things that can be considered as part and parcel of your estate, which is not the traditional items that people tend to think about. It may not be worth millions of dollars. In fact, it could only have, for you, sentimental value, and therefore it will be priceless. Or of course, it could be something that only has a modest value in terms of money. So therefore, it is important to recognize that your estate, my friends gathered here this evening, is really whatever you own. It's what you have the ability to leave for those loved ones, and perhaps those not so loved behind. When you go to those pearly gates, you can leave it for those persons. Now, there are obviously lots of decisions, and this is where it comes in, what is estate planning? There are lots of decisions that you have to make about this estate before you die. Because the idea is you want to ensure that it's distributed according to your wishes, not the court's and not someone else's. We have to, therefore, think about the pre-planning process. And so we also have to think about those things that are not in our estate. And this is something that certainly in my experience as an attorney, I have seen where persons will come in and they say, "Oh, I own a house jointly with so-and-so, and I want you to write my will, and I want it to be put in the will." And you have to advise persons that no, a joint asset such as a house, which is held in joint tenancy, cannot form part and parcel of your estate in the sense that you're going to put it in your will. Because in truth and in fact, joint tenancy means you and I, or you and whomever else, owns the property in its entirety. I own all of the property, you own all of the property. This business in Jamaica where we say, the room there my own and the room there your own. That is not understood in the law at all. It is not something that the law recognizes in that sense. And so it is important to recognize that those types of assets will not form part of the estate. And sometimes people get the shock of their lives when the entire estate is dealt with, to recognize and to realize that they will not be getting certain assets that they had thought they would be getting. Life insurance policies is another big issue, because life insurance policies also fall outside of the will. Because if you have a life insurance policy, you put more than likely a beneficiary or several beneficiaries on the policy. Those persons will automatically, excuse me, get the benefit of the policy upon your passing, if that is how the policy is structured. Therefore, let's say I have a policy with my sisters on it, because I took the policy out when I was 22 years old and I didn't have children, I didn't have a husband, and my parents were all right, they didn't have health issues. But as I grew older, I changed the beneficiaries on the policy to, for example, my children or a spouse or an aged parent. That's fine. However, let's say, and this scenario happens far too often, you want to change the beneficiary, but you know, life is happening, so you don't actually get around to doing it. And you're always saying to the person, yeah man, John, don't worry yourself. When we're dead, the life insurance policy up at X life insurance company is yours. Lo and behold, I have gone to the pearly gates. John goes up to the life insurance company only to be told that, no, you're not on this life insurance policy. Person who's on the life insurance policy is that person who had always been on it. And so here it is now. John has no recourse in court because based on the law, the person who is named as a beneficiary up until the time that the owner of the policy changes it is going to be the person who benefits from that policy. Business asset is another area. If you're a sole trader, you're a sole practitioner, it's not so difficult when it comes down to business assets being considered as part of your estate. But if you have set up your legal entity as a company or you're a partnership, you cannot treat with the assets as if they were your personal assets, because in truth and in fact, they belong to the organization. And there's actually a case in the criminal courts in Jamaica now where it is alleged, and note well, it is alleged that the business assets of the company were treated as the personal assets of the owners. And so there is an ongoing issue where that is concerned. Of course, what exactly does joint mean? I just ran through that. No, it's not as stiff as we would think. It is that legal concept that dictates how property can be held. You may say, so how is that different from tenants in common? Certainly as it relates to property, houses, land. Tenants in common means a percentage of the property can be owned by various persons. So I could own 10% and you own 90%. You could own 50% and I own 50%. That basically means I can do whatever I want with the property, my 50%. You can do whatever you want with the property, your 50%. Now, who are the people that you should be considering when you're making your estate plans? Obviously, your spouse, your significant others, or your dear friends. It took me a long while to recognize that when people talk about their dear friend, certainly in Jamaica, it was a man and a woman who were in a relationship, but they were not married. I didn't realize that until well into my later years. Most persons who have a spouse, a significant other, will obviously sit down with them and say, well, Why I want to make my will, or I want to make plans for the future. You as my spouse, you are going to be the one who will be in charge of what is going to happen to my business, as it were, my estate when I go. But what about if you are not married? Or what if you are, excuse me, not in a relationship at all? How then do you treat with what is in your estate? It is in the law now in Jamaica because of certain very distressing situations that occurred, whereby a man and a woman who had been in a relationship, single man, single woman who had been in a relationship for a minimum of 5 years, if one should die, the other can go to the court, and it's usually, unfortunately, the woman goes to the court and petition to be known in law as a common law spouse. That is something for a whole other webinar. But suffice to say, that particular person would then be able to deal with your estate if certain things had not been done by you before you passed. Another set of persons to consider, minor children. Remember, children will need to go to university. They will need to, if they have special needs, you're going to have to make sure that is taken care of. There are many persons who are taking care of their grandchildren, certainly in our Caribbean communities, taking care of their grandchildren as if they are their parents. Those children or grandchildren will also have to be considered when you're making your estate plans. There are persons who are taking care of their elderly relatives, whether it's your aunt, your mother, your father, grandfather, other elderly relatives. They too can, excuse me, can figure and ought to figure in your estate plan, because yes, you love Uncle Joe, and yes, Aunt Mary is the best grandmother ever. But when your eyes close, the people who are left behind might decide, yeah, time for dash her out on the road. So you will have to make sure that you put the proper plans in place so that all that you want to be done is actually done. And as I said, what if persons have special needs that is going to need a lot of medication? They're going to need to always be having, whether it's surgeries or they have to have changes in their prosthesis limbs or their wheelchair. There are quite a number of things to think about. And obviously, it's important that you think carefully if you're going to be leaving, for example, large sums of money to young people. Nothing is wrong with being young, but we all know that sometimes people don't make the best decisions where money is concerned. And it has been said that the younger you are, sometimes the more likely it is that you may not make good decisions with your money. And so you have to consider, do you really want to leave $10 million to little Johnny, who's just 21? Or you have to really consider if you really want to leave just yet that house to sweet Sarah, who has just turned 22. Because not only can the funds be dissipated by the actions of the beneficiaries, but other unscrupulous persons can help themselves through trickery or otherwise to the fruit of your labor as it is, or as it was. So you have to consider those things very carefully. So we've done all of that. It's been quite a mouthful. And we are now thinking about making our estate plan. Two main things, my assets, my liabilities. I'm no accountant, but those two terms I am fairly familiar with. So you think, what are my assets? What are the things that I actually own? You can think about the things that you own outright. You know, you don't owe any money on your mortgage, for example, with the National Housing Trust, if you're in Jamaica, or another entity, if you're in another Caribbean island or another country. You think also, what are my liabilities? Who do I owe? Oh yeah, I still have that student loan of X sum of money. Oh yes, I still owe that much money on my mortgage. So you draw up a picture, almost as it were, of all the things that you can think about. And this is crucial because now it's actually grounding you, and it's making sure that you can get a clear picture, not a picture through the rose-tinted glasses of what we would all like to think we have. It's actually forcing us to reckon with what it is that we do have. And so you make an inventory, as it were. And the inventory list, I have an inventory list that you can send to us for by email, and we'll send that out to you. You're going to make an inventory, the detailed checklist of what you have, and of course, as I said, what you also owe. And be very ruthless with this part of the exercise, because if you're not honest with yourself, it doesn't make sense. When you're making this inventory, it doesn't have to be anything sophisticated. Pen and paper is good enough. You can use an Excel spreadsheet if you have one. You sit down and you go through and you say, okay, yes, I have that, I have that, I have that. Stick a pin. Where are you going to put this? Because we're going to talk about this later on. But when you have done this inventory, if it's on your computer and your computer is password protected, that's going to be a problem when you go, because you're going to be putting on your inventory list the location of this particular asset. I can think of a case that a colleague of mine had where after the testator died, that's the person who made the will, the family was told, by the way, of a property that was owned, but they could not locate the property. That proved to be a significant problem, because what it now means is that much time, effort, and money will have to be expended to locate this property and to make sure that it actually, excuse me, belongs in the estate. It wasn't my case, so I'm not quite sure what happened at the end, but it reminds me to say to you, my fellow listeners here this evening, that it is important for you as the testator to say where certain assets are located, so that those who are going to be dealing with your estate don't have too much drama to deal with when they are beginning to do the work. The issue now, who gets what? That is entirely up to you. And this is another good reason to make sure you have your estate plan, because you can decide. You don't have to have a situation where the court decides who is going to get what. Because invariably, the court may make a decision that if you were alive and well, you would not have made. Some persons will say that if the dead could get up and walk, they would, when they see the types of decisions that have been made in cases that have gone to court because of how the estate was being distributed. You also have to think about who is going to be in charge. Who do you trust? Who are the persons in your life that you can say, boy, if something happened to me tonight, I can call John. Who are those people in your life? Because you are going to need people who are trustworthy, because remember, they're going to be dealing with your money and your other assets. You need people who will be willing to stay the course, because sometimes dealing with an estate after somebody has died takes a little time, and people have to be willing to put that time in so that your wishes rather can be respected. And who really cares? You have to care. And because it is your money, you work hard for it, your sweat and blood, you have to make sure that whatever you put in place is good enough. The person who's going to be dealing with it is almost walking like you. So what should you do? A will, trust. What about a power of attorney? Should you, give it all away before you die? Make them fight over it? If you forget about it, them can sort that out. Or I'm leaving nothing, and therefore somebody might have to choose, seek to get letters of administration. So we'll go through them quickly, and then I'm going to do will in details. A will, everybody recognizes that a will is a written document. So I'm going to talk about a trust. Most times people will leave a trust in circumstances where, for example, there is a person who is a beneficiary that you have a concern that John Brown, Tom Stokes might dissipate what is in the estate for him or her, or it's a minor. And so that money is held until that person reaches his or her majority, and then he can take the money and waste it away if he wishes. But that's his business. What about a power of attorney? Some people do not recognize that a power of attorney ends with the death of the person who gave the power of attorney. So if John Brown gives Tom Stokes power of attorney to do whatever with all of his property, that power dies with John Brown. Some persons don't realize that, and it sometimes causes problems. So it's very important to recognize that the power of attorney dies when the power of attorney dies with the person who gave it. I seem to be frozen. I don't know if people are hearing me. Could somebody indicate?
We're hearing you just fine.
Hearing you loud and clear.
Okay, great. Can you see? 'Cause I can't see me.
Perfectly seeing your
We're
screen.
seeing you, yes, as well.
Okay, great, wonderful. I can't see me, so let's just hope I don't do anything funny. All right, so we have talked about trust. We've talked about the power of attorney, giving it away. Some people decide that, can't bother the stress of this year, so I'm going to give it all away. Wonderful. But there is a little caveat. You don't know how long you're going to live. Even if the doctor told you that, John, you only have 2 weeks, get your bucket list done. You may well outlive some very old people. And so whilst that is an attractive idea, it may not be the best idea. So I would say—
Nadine, sorry to interrupt. The presentation, the slide.
Oh, okay, hang on.
You're at the end.
Okay, I did this one. Let's see. I don't know, I can't see my picture anymore.
You're here with us, Nadine?
I think your mic is muted.
You're muted, we can't hear you.
Okay. Can everybody hear me now and see me again?
Yes, clearly. You can go ahead and share your screen.
Yes, we are.
All right, I do apologize for that. I do not know what happened. The Zoom gods do not seem to love me tonight. All right, let me go to the next slide.
You have to share again. We're not seeing.
Okay, let me share again. All right, I'm going to share the screen again. All right, everybody seeing?
Yes, we're good.
Okay. Wonderful, I apologize for that. Yes, so I was at the point where I was saying, yes, you can give it away, but just in case you outlive all of those people you gave it to, you might have a little problem. Let them fight over it, maybe, but the better course of action would probably be to put something in place. And of course, if you really decide, me can't bother, let them fight, just let them go on. Somebody at the end of the day is going to have to get what is called letters of administration. We'll talk about that in a minute. So let's go to our next slide. Now, what does the law actually require of a will? The person who makes a will is called the testator or the testatrix if you're female. But throughout this presentation, I will most likely be saying testator because the male in law also represents the female. And I do apologize to those of us on here who might say, no, you need to make sure you're differentiating, but that is how it is in the law. The law requires that the testator has what is called mental capacity and legal capacity. Legal capacity, you're 18 years old at the minimum. So no minors can go about making a will, just like how minors can't make a contract. Mental capacity, which really means that you're of sound mind and judgment. And so you were not influenced unduly, you were not forced, there was no fraud visited upon you in the making of this will. And so when you make your will and it goes to the court has to be confident that when Nadine was making her will, she was of the requisite legal capacity. And I just passed 18 the other day, but I also have the requisite mental capacity, or I had the requisite mental capacity at the time when I was doing my will. That's one of the first hurdles. The law also asks of you a particular format for the will. So it has to be in writing. You can handwrite it. There have been wills put before the court that were done in the hand of the testator. Or you can type it on an old-time typewriter. You can type it on your laptop and print it off and get it dealt with. What is not possible under the law as it stands in Jamaica is, for example, a video will or something you put on Instagram or Twitter or any one of those social media platforms. It has to be done in this particular format. And of course, we suggest that one uses plain language for the disposition. You see, have it there, plain language. So no they that thus, them, thems, and them kind of something in the way. You want to make it clear. You want to say the disposition, that's just a fancy word for the gift that you're giving, is clearly identified. So it's not going to be, I am giving my car to my brother, because that has lots of problems right there. I have several cars. I have several brothers. Which brother am I talking about? Is it the favorite brother? Is it the brother who ran away to England with all my money? Who? So it would be better to say, I, Nadine, am giving my blue Toyota Tundra, 1987 blue Toyota Tundra, to my brother, John Brown. Some people might say, oh, but suppose there's more than one John Brown, you know, if you're giving something to a friend. So you have to be a little more, put a little more clarity to it. You could say, you're giving your Toyota, blue Toyota Tundra, 1987 blue Toyota Tundra to John Brown, who lives at such and such, or lived at such and such, or who was my best friend in high school, whatever. Something that the court can use to feel sure that this is the person who is to get the gift. So that is very, very important. Also of great importance, signing of the will. We could have made all of these great estate plans and we could have written our will and we forgot to sign it. Or we didn't even realize that it had to be signed. The law requires that the testator, that's the person making the will, signs first. And he signs or she signs this at the foot, the law says at the foot or the end of the will in the presence of two persons. So when you're signing your will, you would have already thought, who would be a good witness? So now I tell everybody my business as to what is going on in my life and what the fact that they thought I had $10,000, it turned out to only have two. You're going to find two persons in whom you repose trust and confidence. And you're going to say to them, John, I'm willing and I want two people to sign it. Could you do it? And they will come to you or you will go to them and you will sign. This is crucial because you have to sign, let the two of the people see. These two people must see you sign. They are going to sign as well, but they don't have to sign at the same time. So you sign, the two of them see you put your pen on the paper, and then everybody can go their separate ways. Then John Brown can come and sign as a first witness. Thomas Joe can sign as a second witness. Now that is crucial because if there's a misstep, as I have noted here, it can make the will invalid. And that's another ballgame that you don't really want to have to. You see, it says there, failure to follow the procedure is going to result in the will being invalid. Now, what about a circumstance where somebody signs the will on your behalf? Let's say, for example, I can't read and write, but I can certainly speak because I am not stupid. I am just unable to read and write. So I will say, dictate, leave my this and that to this person, leave that to that person. And then I will say, John, can you please sign my name? Or I can say, let's say I am totally different, or I'm blind, for example. Then you can make an X. I think many, many years ago when, you know, certainly in Jamaica, so many of us were not privileged to access education. Many of our forefathers could not read and write beyond, you know, the very, very basics. And some of them could not even do the basics. So when they made certain documents, they would put their X, mark your X. So the person who's a testator would mark his X, and that would be considered to be a valid document because it is really saying John Brown understood the content of what he was writing, or what was being written in the will. Now, corrections to the will, excuse me. And you will notice here, I put the white gray Lancer. And I've put what I purport to be 3 signatures there. The law requires that if there are corrections to the will, that they are signed as close to the correction as possible, whether you're going to put it to the end of the paper, you know, on the right side, or underneath, or some people put it above, to show that there was no chicken business going on here, as we would say in Jamaica. But I made a mistake. I have 2 cars. I given my sister the white one, but I given my brother the gray one. And so I sign it, and the witnesses witness as well. Because when we're dead, we don't want a situation where all of a sudden people are saying, no, man, I remember when he said it's the white one she must get and not the gray one, because the gray one mash up now. So nobody wants the gray one. So the law in its wisdom says, please correct any, please to sign any correction to the document so that we can feel confident and feel sure that this crossing out is true. Is a true crossing out, i.e., it is the will of the testator. Now, what about this business of witnesses? Remember, we said that the witnesses are very, very important, very crucial. They are signing and to say, yes, I saw when Nadine signed her will, and it was Nadine because I've known her for so many years. But there are a few issues as it relates to witnesses. For example, can a witness receive a gift or the witness's spouse? I always caution against that. And the general rule is that you recommend, if you're asked in your capacity as an attorney to assist someone in a will, you recommend that a witness is not also somebody who is being considered for a bequest in the will. Enough people out there can witness your will. Don't bother go through the stress of having that all have to be distilled in the court. There are a few specific circumstances where that is permissible, but the court will still have to look at every case. So the general rule of thumb is it is preferred not to have a witness be somebody who is also getting one of the gifts. Because if it comes down to it and that happens, because life happens, it has to go to the court has to make a decision, and the court may well say, no, not feeling that this should happen, and so you're not going to get the gift. And the gift is going to go into what is called the residue of the estate to be distributed generally. So the better course, no witness should really be a beneficiary of a will. Executors. No, that is the person who is charged with standing in your shoes, doing your business in the way that we would have expected you to do it. So the executor has a very, very significant role. As I said earlier, you must repose great trust and confidence in this person. So whether it's a spouse, a friend, an attorney, your brother, family, friend, but somebody who you trust, somebody who you trust in your business. No. How many executors should we have? Minimum of 2. The law speaks a maximum of 4. Anybody can be appointed as an executor as long as he's of legal capacity and mental capacity. So obviously you can't appoint your 16-year-old son to be your executor because that person is not an adult. Why are you getting more than 2? Because, and it happens, God forbid, one of the executors refused to act. Lucky, bad breed, pinning them, and I do nothing. You don't do anything. And so John Brown has died, the will is there, nothing is taking place. Now the other executors can take up the mantle and say, all right, I'm going to take this will to the court, head down to the court with the relevant documents so that the will can, you can get the grant of probate to do all that is necessary. Persons always ask, do executors get paid? The law stipulates that there can be payment, but most of the time you will find that it's a family member or close confidant, and they may defer from taking that stipulated income. Of course, there are services and attorneys and other entities who do this as their professional calling, and so they would take those fees. Importantly, when does an executor begin to act? The executor begins to act upon the death of the testator. So that situation that I know of where the executor was the wife and the testator was lying in the hospital, fairly sick, perhaps not going to make it. And the wife begins to tell the lawyer, you need to do this and you need to do that. And I want to sell this right now and this and that. No, the executor has no standing at this point. The testator is still alive and fairly kicking. It is only upon the death of the testator that is the only time when the executor begins to act. Sometimes persons don't understand that, and unfortunately, as we would say in Jamaica, overstep them bounds before the time, and that is important to recognize. What about the marriage? If someone gets married, what effect does that have on a will? The will is invalidated immediately. A marriage automatically revokes a will, and that is something that persons sometimes don't recognize. You're married, you get divorced, you fall in love again, and you get married. And you say, okay, what am I going to do now? I have that will from a long time. But that will is now invalidated. You need to put new things in place for this new spouse, this new love of your life. The old will relating to the old spouse, if there was one, is out the door. And sometimes the former spouse believe that he or she still have rights. No. Once you get married, if you had a will before that, and you got a divorce, you get married, remarried, that old will out the door. Prenups. In various countries, especially parts of North America, you know, you see it on TV, they're always talking about prenups. For various reasons. It can be to protect your vast empire. It can be because you have family money. In Jamaica, there is the concept of prenups in the law. I myself have never used it, but I know it is there. And so persons, if you're making your estate plans and you've come into your millions, or you worked hard and gained your millions, if you wish, you can examine that. I spoke just now about a divorce and how that can affect certain things as it relates to a marriage. One of the things I usually find is that a divorce really affects things like the life insurance policies. So you had your wife or you had your husband on the policy, and you get a divorce and you forget that you had that policy and you die, that person still gets the money out of the life insurance policy. And there's nothing that the new spouse can do about it, nothing at all. So that is something very, very crucial to remember. Could we have the second poll, please? Right. What is your estate as you currently think about it based on what we've been talking about here?
Good day, Nadine. We have some questions in the chat. I don't know.
Oh, could you tell me, because I don't want to lose you guys again. After the poll, could you tell me, and I will just
No problem, Mrs. Atkinson-Flowers. I'll read the questions to you.
All right. I'll just give the poll 1 more minute. People are typing fast and furious. I don't want to be disrespectful and end it.
Hello, Nadine.
Yes, sir.
Would it be better if you were to go through the presentation and then take the questions for the sake of a better flow?
I could do that. It doesn't really matter.
I know generally what tends to happen is that I don't know if there's a time limit on this.
Yes, I think we're to finish at 8. I am trying to get through. I have about 7 more slides. So yeah, I will just hurry and go through and then
probably take the questions after that, yes, because I fear that if we start taking the questions, you might not finish the presentation. I know from experience.
Yes, absolutely. This is true. All right, so I'm going to end the poll. Thank you very much, everybody, for answering. Most persons have said that their estate consists of property, money, investment, clothing, and car. And investment is very important because, you know, sometimes you forget that you have that $1 million worth of shares in Amazon or whatever it is. So those are important points to remember. I'm going to close the poll. Residuary clause. What exactly does that fancy term mean? It simply means that there's a catch-all clause in your will. And it says, all the rest and residue of my estate I give and bequeath to so and so and so and so and so. It means that if, for example, something comes into your estate and you didn't specifically speak about it, it falls into the residue. Or if a gift to a beneficiary fails for one reason or another, that too will fall into the residuary clause. And so it's important that your will actually has that fancy language. You give and bequeath all of the things in your residue to whomever. When the beneficiary or the devisee dies before the testator, just that happens. You're leaving a gift to a family member, you know, your son, your daughter, God forbid, he or she passes before you. What's the general rule? The general rule is that a gift that you give to someone and that person dies before you, that gift fails. That's what the law says, that gift fails. But there are some particular exceptions under the law. And one of the main exceptions is that if you left a gift for a child your child, and that child dies before you, the gift can go to that person's child. So it goes to your grandchild. So there are lots of cases in Jamaica that I know of where, for example, the child has died and the other family members say, well, you know, I have nothing to forget because your mother did forget it, so you not get nothing. No, that is incorrect in law. That grandchild, the gift is to go to that grandchild, despite the fact that, that his mother died before his grandfather or his father died before the testator, if it's that sort of a situation. So it's very important when you're making these decisions to think very carefully and very cautiously about what you're doing. Rights and duties of the beneficiaries. No. Sometimes people don't even know that they're beneficiaries, to a will. I've heard of situations where they read the will, have the big gathering and do it. The law doesn't really require that of you, but it's prudent that persons know that they are beneficiaries to a will. So what are your rights? You have a right to know that the will is being probated. You have a right to know that at the end of the process, you will be getting the X, the Y, or the Z. What should you not do? First of all, you should not go about getting yourself into all sorts of debts and problems to say, oh, I have 10 million coming in from my father's estate, so I can run up a debt here or run up a debt there. That is not acceptable to the law where these things are concerned, because the will still has to go through the process in the court. Persons are feeling very charitable these days and they want to leave something to their high schools or their church and all sorts of things. That too is permissible. A lot of times persons, when they're leaving to charities or other institutions, they give them that very specific part of the will that speaks to the gift that they're supposed to get. Now, what is it that the executor is supposed to do? He or she is to do what we call seek probate. So he or she petitions the court, tells the beneficiary, you are in John Brown's will, and this, as I said, the reading of the will is not something that truly the law requires, but at the very least, you should be made aware of what's happening. The executor really, as I said before, stands in the shoes of the testator and does all that is necessary, collects the assets, pays the creditors, sells assets in the estate to be able to pay creditors. Taxes, don't forget that. Your death taxes. The government always wants its share. And of course, the happy day. What's in the estate is distributed to all of the wonderful beneficiaries who have been so patient and all of the creditors who have not been knocking on your door. And after that is done, the executor proceeds to give a final submission to the court that he or she has done with the estate all that should have been done, and it has all been done properly. Creditors, as I said, if you are a creditor, you have a time frame within which to say, yes, John Brown was lent money by me and so on and so forth. Second point, a lot of times people come out of the woodwork, yes, she owed me, yes, he owed me. They need to have some kind of documentation to prove that yes or no, they were doing business with this person. The quick comment here that I have as well is, for example, a lot of small business persons may tend not to have really good records, and this is a good place when you are doing your estate planning to make sure that nobody can come and say, you know, me lend him $40,000 for XYZ. Good records. Good records are key to estate planning. And of course, we talk about the court's role. The court's role is really to ensure that all that the testator wanted done is done. What if there's no will? You can petition the court for what is called letters of administration. Somebody stands in the stead of the testate. Well, the person was dead. Intestate is what you call that person, because he died without a will, or she died without a will. Or letters of administration with the will annexed is a circumstance where all of the executors fail to act, or God forbid, have died. And so somebody else has to come forward and do all that is necessary. We also have what is called the Administrator General role. The Administrator General tends to come in play when they are minors, sometimes, and there are issues that have to be sorted out. And finally, our last lick. Is dead left really worse than OBIO? You give your will to somebody for safekeeping. You tell persons that they're in your will. Next thing you know, them kill you. You might want to keep that secret. What if you live overseas? You know, lots of us migrate from our home countries. You can do your will wherever you are, and you can, if you have assets in your home country, those assets can we do a process called resealing the will, which really means everything was sorted out, got probate in country A, country X has a reciprocity agreement, you take the will to the Supreme Court in country B, and all the assets there can be dealt with as well. And that pretty much finishes the presentation. This is my book that Tamoya spoke about. It's called On Your Feet, Criminal Law Practice in the Parish Courts in Jamaica. It details really what happens in our parish courts in the criminal law jurisdiction. So it's a good read. It speaks about jurisdiction, fingerprint offenses that are there, the whole gamut. And I figure in this day when we're having so much misinformation, it's always good to have good information and to know what is really happening in our courts, because we all play a role in the justice system. If you want to get a copy of the slides or the inventory list or the wills checklist, you can get my email, and there are all my other details. And we have a few minutes, I think, for some questions. So we can open it up for questions. Tamoy?
Yes, thank you so much, Mrs. Atkinson-Flowers. So as you rightly said, it's question and answer time. I'm gonna ask anyone to just please raise your hand. We'll identify you and you can come onto the mic and ask the question. I noted some already in the chat, but please feel free to come on and ask some of your questions if you are so minded right now. So this is your time to shine. Please ask your questions by raising your hand. But while we do that, I noted one in the chat. Can you leave your entire estate to the executor?
Some people tend to do that because, for example, let's say it's going to be your spouse. So that's a pretty, you know, you're not expecting your spouse to do wrong by your children. So sometimes people do that. I see somebody has raised their hand.
Thank you so much. Yes, oh, sorry, go ahead. Yes, Shawnok with two kids at the end. Yes, her hand is up, so you can unmute and go ahead.
All right, so my question is about trust. You have young children and you want to create a trust. How do you go about creating a trust?
Oh, that's a whole nother seminar. But essentially speaking, as you say, a trust is for many purposes, but for minors, there is a particular process that you have to use. It is really to ensure that the funds go to those children. So you don't have an executor, you have a person called a trustee. And this trustee, for example, every school term gives Nadine or $20,000 to go to UE, give me my lunch money and so on and so forth. And when I reach my majority, you know, when I'm 18, sometimes it can be stipulated when I'm 21, I get the rest of it. A lot of the time they do trust because they don't want you to dissipate your funds. You know, you're young and you're foolish, you might just spend it off on God knows what. So that is the bare bones essence of a trust. I see.
Thank you, Mrs. Atkinson-Flowers. I'm going to read one from Sharon and then we'll, sorry. I feel like I'm talking over you just a little bit, but I was saying I'll read one from Sharon.
Sure.
Okay, and then we're gonna have the ones that raise their hand. So Sharon said, how long do you have to challenge a will as a beneficiary who was not given the assigned gift?
Okay, let me make sure I understand what the question is saying. Is it that there was a gift to Sharon in the will and Sharon didn't get that will? Sorry, didn't get that gift. That's how I'm going to interpret it. So the person can tell me if that's wrong. If it is that there was a gift bequeathed to you in the person's will, in the testator's will, the only way I can see that you would not get that gift is if for some reason the gift failed. If the gift failed, as I said before, it goes into residue and it goes another way, but did not get the gift. Could you be also meaning that the executor decided that we're not giving it to you? In such a circumstance, then you have the right to go before the court. As to how long, there's no real time frame. To go before the court to say, here it is in the will, I'm supposed to get XYZ, the gift is valid, I have not got it. So if those would be the two scenarios as I understand what you're saying. If that's not what I'm to understand, then you could probably retype or raise your hand and let us know. I see a couple of, several persons with their hands raised. Tamoy.
Yes, I see them as well. So I'm going to take Frederick first. You can go ahead, unmute and ask your question.
Thank you very much. I just want to clarify if executors can be beneficiaries of a will.
Yes, because as I think I mentioned earlier, that for example, persons make their spouse, but it's kind of untidy. I personally prefer if it's someone else, because at the end of the day, it's quite a bit. It's quite a bit to do.
All right,
Patrick.
We're going to go to Patrick.
All right, thank you very much. Excellent presentation. My question is, you did mention it at some point, executors and payment. Are they supposed to get paid? Is it that they get a portion of the monetary value of the will? Can they make demand about payment?
Well, most wills act, because practically every jurisdiction has a wills act, and it speaks to percentages for executors. I think I mentioned earlier that in some cases, the executors are family members or close friends, close family members, and so they will not take that payment. But the law does provide, because it recognizes what the executor is doing. So the law does provide. I don't recall how much it is now, but there's a percentage noted that the executors can access as their fees.
I think it's 6% in Jamaica.
I don't quite remember, but there is a percentage that they can actually get.
Okay, thank you very much.
Yes.
All right, I'm going to take Judith right now, so you can unmute and ask your question. Judith Baines.
Yeah, good night, everybody. Mike, are you hearing me okay?
Yes, sir.
Right, okay. My question was, are there any benefits, once you've gotten to a certain age, maybe 70s or so forth, to instead of leaving property in your beneficiaries indicating it on a will, to add those persons, say it is your spouse or your daughter or whatever it is, to add them instead to the deed as a joint tenant versus having to go through, probating of the will and so forth?
Right. Well, let me answer it this way. I don't want to sound like a lawyer. There are pros and there are cons, because if you add me, and I would love it if you add me, it means that obviously we don't have to go through the whole issue with probate, because if it's just the two of us and it's joint tenants, I'm younger, the law of age suggests that you will go first as opposed to the younger person, and the younger person upon your death will only need to do what is called note the death of the other joint tenant, and so the certificate of title will only be in your name. That's not as expensive as going through the whole business of probate. But let's say, God forbid, you do that and the younger person still passes before you, then you're still alone on the title. And so it still is in your estate. But there is value to that, to doing it that way. Of course, you can't get away from the government's cost, because even if you do what is called love and affection transfer, meaning no money is physically passing hand, the government still wants the stamp duty and a couple of the other taxes on it. So,
okay, thank you.
Alrighty.
Thank you, Judith. I'm going to go to Christy Rahim now. You can unmute and ask a question.
Hi, good night. Great presentation.
Thank you.
My question is, let's say both parents are alive. Can I add a name of another additional person to the will? And if I can't do that, do I still have to do a letter of administration after death in case one of the parents died? Or does a will have to go through a letter of administration?
Start again slowly, because I think we might have, say the first part. You're saying your parents are on it as what? They're on your will as what? Your executors?
Yeah. Yes.
Okay, well, if they're on your will as your executors, you don't need to add anybody else.
No. But let's just say one of the parents died. One of the parents died, right? And well, the other parent name is there. So could that other parent add, like, let's say, like their children name to the will?
No. The will is mine. The will is yours. So nobody else can add anybody to the will. It is a document that is personal to me. So if it's my will, I decide who I want to be on it as my executors. But when you mention your parents, that's a good point in the sense that usually older persons are expected to die before younger persons. So it's not such a good idea to put an older person, without being disrespectful to age, because all of us will get to that point. It is perhaps better to put someone who is your age or slightly older. It's not prudent to put somebody who is 80 years old on your will as your executor when you're 35 or 55.
Okay,
and
oh, sorry, I don't know if you were finished.
No. And you were saying something else about letters of administration.
Yes, I wanted to know if you have, if a will, does that have to go through a letter of administration?
Oh, it's two different things. Letters of administration exist when, first of all, there is no will, or secondly, there is a will, but there are no executors who are willing or able to act. So it's two totally different things. So one is the document you do for yourself. You're the testator, that's your will. Letters of administration, you died without a will, you're intestate, or you died with a will, but none of the executors on the will are willing to act or able to act. Them dead, them can't bother, them did hate you, they don't know why you made them their executors. Then letters of administration will come in. So it's two different concepts.
Oh, okay, I understand. I just have one more question at the same time. After a letter of administration has completed its full process, will the deed then be taken on the, will it go to the executor name?
It passes through anything. Let's say it's your will or the letters of administration came to you and John Brown is to get the property. It passes through whoever is in the stead of the testator or the personal representative, sorry. And then it goes to the person who is supposed to get it. So it passes through the person. It's not going to stay there. It's not going to stay in Nadine Atkinson-Flowers' name because I'm the executor. I am just the conduit to get it to you who is the beneficiary.
Okay, thank you.
All right.
All right, we're going to go to, let's see who I got first, Robin. Robin, you have your hand up. You can unmute and ask a question.
Yes, good night. The executor is the daughter of the testator. The testator gets married and became senile. Can the husband, the new husband, change the will without the knowledge of the executor?
First of all, if the testator is senile, they have to go to the courts. Nobody, remember, the will, it's so personal. The will is such a document that the court frowns significantly upon anything that seems to be thwarting the will of the testator. So there is nobody who has the lawful authority to just cross out my name and put in yours, because that's basically what you're saying. Somebody is saying, okay, John is senile, let me put things in place in the will. No, that's not how that goes. There has to be. Yes,
I'm just thinking that the new husband may, you know, take her to wherever and change the will, and the person who, I don't know how it's done, but could he do that without the executor knowing anything about it? Is there any loopholes?
Remember, you know, that the executor is not the will, don't belong to the executor, nor the will, it belong to the testator. But you remember when we talked at the beginning, we said that one of the things that is necessary for a will to be found to be valid is mental capacity. So I don't know how many people remember this famous case some years ago with this very elderly gentleman who married a very young miss in the United States, and her she got everything in the will basically, and his adult children, many of whom were older than her, challenged her for the estate, and they actually clawed back significant portions of the estate from her because the court found that at the time the testator was suffering from a mental defect. But that is something that would have to play out in the court. He was maybe in his late 80s and she was about 25. It's a very, very famous case in the United States about maybe 10, 15 years ago. So the court wants to make sure that you are not suffering from a defect, whether it's senility, dementia, whatever.
All right, we have more hands up. Oh, I'm sorry. Are you finished with your question, Robin?
I was just saying thank you.
All right, great. All right, debt/cons, Jeffrey McKenzie, your time to shine. You can ask the question now.
Oh, it's Detective Constable. Good night, everyone.
Good night.
Question I want to ask though, I know based on law, it's admissible that a declaration, a verbal, a dying declaration is admissible in court. What if a will wasn't prepared, but the person through declaring or through verbal state that I want this person to take over my estate? Is that legal?
No, but remember, no.
All right, it seems we lost Mrs. Atkinson-Flowers there for a bit. All right, I'm sure she's going to be rejoining very soon, but please continue to post your questions in the chat. Remember, you can also request a recording, and we had put the email in the chat, so you can, all right, I think she's back now.
I am back. I don't know what happened.
Awesome.
I think maybe because we have so many on, it's kind of iffy tonight. Detective Constable, when you speak of a dying declaration, remember, that is a very unique creature to the criminal law, whereby you still have to prove certain things, because in a dying declaration, you have to have a settled certainty of death. That's what makes it admissible. So that's a different creature to deal with particular circumstances where it is that it's a will. I can come and swear and take God off of the cross that yes, John Brown said so and so and so and so and so and so. But it could be fraudulent. So that is why the law requires of us that if you want to leave something to somebody, you write it down. Because if you don't write it down, the court will write it down for you. And you may not like what the court writes. So it's, you know, it's kind of two different creatures, as it were.
That's true. Thank you very much. And I must commend you. It's a very good presentation, very much informative. I'm going to request a copy of such so I can
absolutely.
share with my colleagues.
Absolutely. If you can send us your email and we'll make sure to send it to you.
All right, thanks much.
All right, thank you. We're going to go to Daniel now. You can raise your, well, you've raised your hand rather, so you can go and unmute the microphone and ask your question. Daniel.
Thank you. Great presentation. Let me get right to it. I want to keep things simple. I just want to write a will. I've laid out all of my assets, all of my liabilities. I've chosen who would be the executor. Just clarify two things for me. All I need is for them to sign, or do I also need to have a lawyer involved?
No, let me put it to you this way. A lawyer is like a doctor, you don't have to have one. But if any problem come up later on, because whilst you say it's simple, it may well be because you have decided your $20 million, you're going to just leave it to your 2 children and your husband is going to be the executor. Fine. But remember all the things that I talked about at the beginning, you have to make sure that the will in its entirety is valid. So you do not have to have a lawyer to do your will for you. I've come across many will forms in Jamaica that we've taken to court for probate and it's been granted. But I've also come across them where we've taken them and they have not been granted. So you can do it by yourself. That's not an issue. But the problem is, after you gone now, oh my God, this might be an issue. So you have to be careful. Not dissuading you. Don't think I'm dissuading you at all. But you have to follow the thing very, very carefully.
All right, understood. Then my last question, if I make a will before I get married, right? Is it invalid if I get married afterwards?
Yes, ma'am. A will, hear the fancy language, a will invalidates, a marriage invalidates a will. That's it, the law says that. So once you get married to Mr. Right, you need to make sure you do a new will and tear up the old one and throw it away.
Okay, thank you so much.
Yes, ma'am.
Thank you, Daniel. I'm going to go to Miriam. You can now ask your question to Mrs. Atkinson-Flowers.
Good night, everyone.
Good night.
My question is, can you leave an equitable interest? For example, that interest you might have in a house, if you paid half for a house or something, or you build something in the house, but you don't have a title document like a deed, can you leave that interest in a will, please?
That's a very interesting question. I'm going to lean on yes, but I'm not 100% sure because it depends on how the equitable interest is held. I'll walk it through quickly, but I would love to do a little more research on this part of it. If the equitable interest of which you speak is, for example, that you paid the mortgage over the last 5 years for a house, you may not be able to leave that equitable interest because truly the law wouldn't recognize that because your name not on the title. Remember, we talk about pen and paper. That is the most crucial thing. But it's not looking like it would work because you would have had to have legal ownership of the asset to leave it.
Sorry, can I just explain a little bit more? What I'm talking about is, for example, those situations where you have adverse possession or your family is living in a house for like, say, many, many years, and it just goes on from one child and the parents to the child and so on. So there's no title document for the house in that situation. Can you leave that house in a will?
Oh, you mean like those, what you call those again now? Like unregistered land kind of thing? Is that the kind of?
Yes, it's unregistered, but there's no will or nobody has any documents for the house.
Right. I can't say off the top of my head that would, I mean, you can write it down, but when it goes to court, I don't know if that will necessarily stand up. I don't know, but that is an interesting conundrum. It's something I could do a little research on and let you know, because there are a lot of what we call family land in Jamaica. Where are you from? You sound like a Trinidad.
I am in Trinidad and Tobago.
Yeah, man. I don't know if the situation is the same in Trinidad like in Jamaica. We have a lot of
situations like that.
Yeah. A lot of family land, and that And that is why you end up having the people fighting over the deadlift, because of the whole heap of drama that attends all of these situations. But that is something I definitely couldn't tell you authoritatively off the top of my head. You can leave it, but as to what the court will do with it, that is another conundrum. So it's something I could check on for you and let you know, but it's not something I
can reach out if anything. Thank you.
Sure.
All right, thank you. We're moving on to Rohana. You may go ahead and unmute your mic.
I don't think the person heard.
Rohana Carnegie. All right, we can move on to Patrick. Oh, she's here. Go ahead.
Yes. Thank you again. Just some questions about the executor. First of all, because you mentioned that you need 2 witnesses to sign, does the executor have to sign anything?
No, the executor doesn't sign.
Okay, the next question was, you said in the duties of the executor, seeks probate, petitions the court. What exactly does that mean?
Fancy language for taking the documents to court, taking the will to court, along with the proof that the testator died, affidavits from the executor if time has lapsed, that kind of thing, and files it in the court, goes back to court when it's necessary after the judge has looked at it to ascertain whether or not it is a valid will, if there are challenges to the will. All of that is what it means.
If you have been very diligent in making your will, you have laid out all your assets, all your liabilities, you have named all your beneficiaries, and no challenges, does that will still have to be probated?
Absolutely, absolutely. Because remember,
have to go to court, basically.
It's the stamp of approval
that
the court is giving you. Because you can't just take up yourself, which is what a lot of people don't understand. They say, John dead, I must get the house, I must get the car, or whatever. Send on. No, that's not how it goes. It still has to go to court for the court to put its stamp of approval on it. Does that answer the question?
Yes, it does. Thank you very much.
Okay. Tamoy, you want to take any from the chat? And I don't know how much time we have left.
Tamoy had to leave, Nadine. But I'm just gonna allow Rohana to go ahead, and then I'll take a question from the chat.
Okay.
Okay. Good night.
Good evening. How are you?
Good. Thank you. Question: my both parents have passed. However, there wasn't a will left. So right now, what can I do to get my name on it? I have a title for the land, but I don't know how to go about getting my name on it.
If both of your parents have passed and none of them left a will, what would have to happen is that somebody has to seek what is called letters of administration.
Okay.
On not only your mother's estate, but also your father's estate. It's almost like doing 2 processes together. And the law says that if parents have died, the first child is first in time to be able to get these letters of administration, second and third, and so on and so forth.
So, but the first child died, and we're 7, and the 7th one, and nobody else cares about it or interested except for the grants.
You would have to account for all of those people. So you'd have to say, big sister died, second brother not interested, third brother kiss him teeth, so on and so on. I'm the last one. They've all agreed that I can get the letters, and then you take all of those documents to court, because the court would want you to account, meaning say what has happened.
What happened to those 4 men?
Yes.
Thank you.
You're welcome.
I came on a bit late, so.
No problem. We're glad to have you.
Okay, thanks.
All right, Nadine, here's one from the chat. Linnell Sylvester asked, can the testator state in the will, for example, that he does not wish for the family home to be sold, but to be maintained as a family home?
See, this concept of the family home is specific in the law. In Jamaica, I can't really speak to other Caribbean islands, but in Jamaica, the family home usually is where you consider to be the marital home. So that is one thing. Family home, when we think about it, usually we say where everybody probably gather. If it is that the family home is only his and he's leaving it to me, him can't tell me what to do with it after I'm dead and gone, unfortunately, because it is mine. So the short answer is, even if the testator said in his will that he doesn't want it to be sold, if he bequeaths it to someone, that someone can do with it what he or she pleases, much to the unhappiness of other family members. And that happens all the time, unfortunately.
Okay, thank you, Nadine. All right, we're running out of time, so I'm just gonna take a couple more raised hand questions. Sharon, you may go ahead.
Good evening, and thank you for a very informative presentation. I have two short questions. A deed of assent. You spoke about property being vested as tenants in common and joint tenants. Under a deed of assent, how is the property vested to the parties therein? That's the first question. And also, can a JP do a will?
You use a term that I'm not familiar with. You said deed of what?
Assent, a deed of assent.
I am not familiar with that term at all. What do you mean when you say that? Yeah.
In Trinidad, a deed of assent is how the property goes from the deceased to the living. So somebody dies and the property needs to be transferred from the deceased to, let's say, my father to me. So a deed of assent is done from my father to his 4 children.
If it is that he had a will or not, how does that work? If he had a will or if he didn't have a will, I'm not sure.
If he had a will and he left a will saying that his house is to be given to his 4 children, a deed of assent is that document that goes from him to the 4 children. How is that property vested in the 4 parties? Is it via tenants in commons or joint tenants?
Right. This is how I'm just going to use my Jamaican experience because I think I know what you're talking about, but we don't call it a deed of assent. Essentially, if it were that in the will, the testator said, the house is to be given to my 4 children. The court, and that's all it says, the court now has to decide how is it going to be held. The most logical way may well be, excuse me, since it's 4 of you, it could be tenants in common, it could be joint tenants. If it is that there is somewhere that we can glean from the will, because it is only the 4 corners of the will, literally, the person can utilize, then it may well be that they could put it as joint tenant, as tenants in common, but I'm not 100% sure. I don't want to speak to the Trinidad situation and mislead you because I'm not so sure how it would work. But I can tell you that if it's not clear in the will, sometimes the gifts, as I said, fail. I think I just saw somebody said the deed of assent may be similar to the deed of conveyance. In Jamaica, we have that. So it's the passing through from the person who is dead to the people who are supposed to get it. But I can't speak to this deed of assent at all with any authority.
Thank you, I understand. And my second question was, can a JP do a will? Because I was told
What do you mean, can he do a will? I'm sorry to interrupt. What do you mean, can he do?
A friend told me that she don't need a lawyer to do her will because she can go to a JP and do it for $300.
Of course. As I said, you can do it yourself too. In Jamaica, they sell the will form in the stores. You can go to the bookshop and buy the will form, and it has a nice fancy language at the beginning. I, Nadine Atkinson-Flowers, do bequeath my so and so and so to this person, my executor, so and so and so. I suppose just like a doctor, you don't have to have one. But if there are issues, then it is sometimes prudent to have one, because after you dead or me are there to harass and perplex the living.
Okay. Thank you so very much.
All right, thank you, Sharon. Janice, you may go ahead and unmute.
Yes, thank you very much. Very good presentation. Not actually Janice, I'm just your account. A quick question. My mother passed away 10 years ago, and she had her will legally drawn up by a lawyer and everything before that. There are 4 children involved. Each of them got a copy of the will, so they knew exactly what was happening. But my mother, she decided to, there are several properties involved, and it was known from long ago who was getting which property. So she decided to transfer the properties before she died. So although they're in the will, they were actually transferred out before. There was nothing really else to probate, because everything else that was in the will, the 4 children just got together and said, okay, Mom said you must get this. And everything was just divided up according to the instructions. So the executor never came into play, because everything was distributed before or right after in an equitable way, no problem. However, 10 years later, some checks start arriving in the mail for some dividends.
There you go.
Nobody knew about this.
There you go.
We can't do anything. You know, these checks are there, and we don't even know where the executor is now. What do we do?
Well, you need a lawyer.
Yes, it's not much, you know, but the point is just arriving. So maybe the stocks are no worth something.
Exactly, because who knows, it could be the $1 million in Amazon share that I spoke about earlier. It could well be that. So one of the first things that you're going to have to do,
and the will did say that any stocks and shares must be divided up equally between the 4. But we don't know what to do.
Her name. And
yes, the checks are coming in her name. Yes, the checks are coming in her name.
Exactly.
And other dividends that were there were jointed, but these ones were apparently we didn't know about them.
Well, without giving you legal advice on this very specific issue and not having all of the facts, I'm going to say, at the very least, you need to find out from wherever the checks are coming from. Do you know where they are without saying where they are coming from?
Yes.
You need to know where they're coming from. Make some kind of contact with them, because sometimes stocks and shares and those things sometimes speak about beneficiaries. So you could possibly have some information from them. If that fails, then you may well have to approach a lawyer to find out how best you can proceed to make it legally known to the companies that your mother has passed. Some of them may well be lenient and say, okay, bring the death certificate, that kind of thing. Some of them may well be hard and fast, because of course nobody wants to get into any problems with the law. So you have, they want to be careful. They're not going to do anything to jeopardize themselves. So at the very least, you need to find out if there were any documentation that might well speak to our beneficiaries, and certainly ask them what they would need to put the dividends in yours and your siblings.
Everybody. And the other thing, the checks usually get stale after 6 months. I'm sure they're going to pass.
So you have plenty of money waiting on you there, man. So you have to act.
Well, it's not a lot of money, but they're just there.
You have to act with some alacrity.
Okay. All right. Thank you very much.
Okay, Jay, you may go ahead and ask your question.
Hi, good night. I was just checking. If I have children and I had created a will before I got married, if when I get married, can the spouse overwrite that will? Or is it
remember, the basic principle is once you get married, any will you did have out the door, you have to do a new will. So once you meet Mr. Right, just immediately draft up a new will, have it properly witnessed, name your executor, and tear up the old one and throw it away.
Okay, so in that case then, if I die, they can't go ahead couldn't change anything, just the
No,
same?
you can't change anything because in essence, you're married, there is no will because the will is almost as if you close your eyes, you open it, the will is gone when you get married. That is how the law sees it, unfortunately. So whilst a lot of us say, when I'm in a will, come in dead tomorrow if I make my will, it is sometimes quite prudent to put things in place, whether you do it, like I think somebody said, their parents put the names of the children and whatever, or you make your will, or, you know, put plans in place.
The other thing is, to the question that the person had asked about the word about passing down of assets. What if the person has like a voice recording or a video recording? Would that be eligible for court
Well, as far as
verification?
I know from our Wills Act in Jamaica, we haven't reached that level of sophistication. You know, the law is always running behind everything else. We haven't reached that level of sophistication because you could come with that and I could say, no, slice it from 10 different segments of when Papa was talking or when Mama was talking. So the law is very, very careful about all of that.
I have one more question and a suggestion. If a will was, if there are parents, right? And say, for example, the father had left a will to indicate that of the 5 children, this parcel of land belongs to child 1, for example. And then the land, the house that was on the land was given to another child. What would be and the house that was there is now rebuilt. Like it's a board house back then and now they did it in a wall house. What is the procedure regarding that? Would it still be valid?
That child who was supposed to get whatever it is can go and challenge it in court, because from what I hear you saying, house 1 was supposed to go to child 1 and it didn't, correct?
Right, so there are 5 children. One of them is to get the house, one is to get the land, but the house is on the other child's land. It's kind of a complicated thing.
Yes, that is quite, and that's what we definitely do in the Caribbean. We always do those kinds of very intricate things that have to be untangled, because as it stands from what you're saying, the house belongs to person 1, but the land belongs to person 2. But I can't take up the house off of the land, can I? So that is something that would definitely have to be sorted out in the court, unless the 2, brother and sister, or sister and sister, brother and brother, can sort that out. That have to be something that is sorted out in the court.
For the suggestion, the person that was asking about the family house being passed down, maybe what they could do is, what I was told recently is that if the person lives there or occupies the land for a number of years and it can be proven, I think it's about 25 years, then I think they can claim the property and apply for title through aggressive possession. I'm not sure.
Adverse possession, 12 years, but it's a little different scenario, because adverse possession requires that you are openly living on this property and nobody is basically claiming it. But in the sense, for family land, me know says Mama own, you know, all 16 children know, and everybody. So it is a little different. It is a little different for adverse possession. Can we take another one from the?
Yes, we're gonna take one last question because of time.
You want to take it from the chat?
1 second.
And I still see we've got lots of hands and lots of questions.
I'm gonna allow L Daily to go ahead, and I just want to some questions are similar in the chat. I just want to pick out one that's not a repeat.
Okay.
Go ahead, L Daily.
Hello, good evening. Excellent presentation.
Thank you.
Question. I saw it in the chat and I would just like to hear what the answer is. The person in the chat asked, if you're going through a divorce, it's not complete because divorce takes some time. You said that at the end of a divorce, you will have to change your will. But what if something happens to you during the time that the divorce is taken to be completed?
What if something happens to you? You mean like you die?
Yeah. So it's in the middle. So the divorce is in progress, but it's not at the end of it, which I can understand. You say at the end of it, you must change your will if you're still alive, but you're in the process.
Well, you must, but you should, you know.
Well, right. But you're in the process.
And so on.
So, but you're in the process of it. What happens during the process of it? And you should die.
These are excellent questions. Now, this is what I would do if I had a client who was going through a divorce and then the spouse dies. I would say you have to look to see the stage of the divorce. The divorce in Jamaica has 2 sections. The first part is called the Nicey. You get the Nicey, and the court allows you a minimum period of, I think it's 6 weeks, to see if you truly wish to be divorced from this XYZ ABC person. If it is at the end of that 6 weeks, you do decide that you have no more love and affection for him or her, you get what is called the divorce, the decree, absolute. The divorce is final, our ties are cut, nothing binds us together anymore. You're not truly divorced if you're only at the Nicey stage. So when you say you're going through a divorce, there can be the stage where you just put in the paperwork and something bad happens. You get the Nicey and something bad happens. If you get the Nicey and something bad happens, whatever was there in the will still go to the person. If you get absolute, you remarry, then so the will that was there is out. But if you're going through the divorce and something happens, you're not yet divorced because the court has not yet signed off on the total separation of Mr. Brown and Mrs. Brown. So whatever is in that will from both of them will still stand if there's something in there for her or for him. So, people have to be very cautious and careful when they're doing that, especially if they have children.
Thank you very much.
All right, Nadine, I'm just going to take the last 3 hands that are raised, and the other person definitely can reach out to you via your email address and your contact information that you shared.
You check the chat there. There's none from the chat that you'd want to.
They're speaking to between the difference between a living trust and a will. I think you spoke to that already.
I don't want people in the chat to feel like they're not getting. They're not. All right. So who are we going to take? Nicola, George?
Nicola, right.
Hi, good night. Just 2 quick questions. I wanted to know if an executor can be a beneficiary. And secondly, when a will is prepared, does it need to be registered?
I'll take the second one first because I remember it quickly because I was actually reading up that today when I was preparing. You don't have to register it, but some people do. In quote unquote long time days, they used to definitely register it. For example, at the RGD in Jamaica, Registrar General's Department. It's not going to be fatal if it's not registered. But some people do register, but it's not fatal if you don't do it. And the first one was if the executor can also be a beneficiary. I said yes, but I want to put a pin in that one. I don't have my Wills Act with me to double check it. So that one I would definitely want to do a little more research on just to refresh myself about that part of it. Usually the executor is not, except in the narrow case where it's the spouse. I've known it to happen, but I would definitely want to reread my Wills Act about that. And I didn't bring it with me this evening to say categorically. So that one, if you wish, I could check on it and let you know.
Okay, great. Thank you.
Okay.
Lohan Noel, I'm seeing a question in the chat. I'm assuming it's the same question that you're going to be asking. If so, you may go ahead and unmute.
We're not following.
Hello?
George, we're going to go with you after, just because we're looking at the chat and it's the same question.
Yes, thank you. I wanted to find out if the will is
2 pages long, and the testator signs on the first page, and the second page has the signatures of the witnesses. Is that will valid?
The court is going to look at that very carefully because, as I said to you, the testator signs and the witnesses signs. Usually, the law requires that they're signing at the same place, meaning the same physical place. What some people do to get around this very issue is they sign on all the pages. Some people do that. Some lawyers, if they're doing a will for clients, everybody is signing on all the pages or at least initialing all the pages. But that very specific question is something that the court would probably have to look at very carefully to see if suppose there is absolutely no space on the paper and only one signature could possibly hold. So that scenario that you put forward is definitely one that I would have to look at very, very carefully to decide if it should still be considered to be valid.
Thank you very much.
Okay, Mr. George, you may go ahead.
Thank you very much. Nadine, very good presentation. Quick question.
Thank you.
Here's an executor who don't know much about court business. So how does he initiate the matter in the court? And which court?
Take for himself, that's the first thing. I'm just kidding. The role of an executor is a heavy one, but it's a burden that there is much information on that you can get. So the first thing that the executor would do upon receipt of the will of his dear friend who is now departed is to flip through it, make a decision that we can't bother with this, just kidding, and say, well, first thing I'm going to do now, obviously, is get the death certificate of my dear friend who is now gone. The court that the court that the person is going to go to usually is in Jamaica, but it also depends, in Jamaica is the Supreme Court, but it also depends on how much is in the estate. In Jamaica, if the contents of the estate is under $1 million, you can go to the parish court to have it done. But if it's over $1 million, the jurisdiction is in the Supreme Court. That is where you would take the will, the death certificate of the testator or testatrix, or if it's letters of administration, you take those things as well. Children's birth certificate, all of that, affidavits that have to be signed up. So it's a tedious process, but it's not a process that does not have assistance to be had. There's some assistance to be had on the websites of the various courts, and there are various textbooks that give some advice as well about it. If it's a small estate, as I said, usually you'll be going to, in Jamaica, we call it the parish court. In Trinidad, I think it's the magistrate's court. I'm not sure what they call it in the other Caribbean islands or in other countries. In Jamaica, if it's over $1 million, you're going to the Supreme Court for the grant or for the letters of administration. So the first thing he has to do, as I said, get a copy, an original of the death certificate of the person, gather up the will, gather up the birth certificates of the testator's children if they are referred to in the will, and of course, begin to see what is in the estate. Oh, you had 4 houses, 2 cars, 7 bank accounts with only him on it, that kind of thing. And you have to keep the will very carefully because let's say, for example, the will, you're just sitting now in this presentation, you start to scratch on the will, all sorts of little notes. We are now into the facing of the will, and that has to be accounted for in court. So there is quite a heavy responsibility for the executor who is
right.
Going
so
forward.
I still don't understand though, when I have all of these things, I just turn up at court one day and say, hey,
no,
I have...
no man, you can't turn up. You have to file paper. You know, court requires filing of papers, filing of documents. There are entire books dedicated to wills in the Caribbean. You gather all of the documents and you have to prepare several affidavits, and you take that. That would take us another 2 or 3 hours to go through. You take that bundle to the court and you file it. And you have to pay the stamp duties at the stamp office. But the first process, the first part of the process is getting the will, getting the death certificate, and birth certificates of children if they are mentioned in the will, and finding out what the assets are. Those are the 4 critical things. And the 5th critical thing, finding out what the liabilities are, who are the creditors that are owed by the estate. And then the 6th thing, gathering them all up. 7th, the affidavits that have to be completed to be taken to court. So that's a short version, literally.
Thank you.
All right, thank you so much, everyone, for your questions. Nadine, I'm just gonna read one question from the chat from Rosemary. She said, in lieu of a signature, apart from using an X, can a fingerprint be used?
A fingerprint? You mean like?
By the testator?
No, that is not permissible as far as I am aware, because how are we going to prove it's your fingerprint, you being the testator as opposed to mine, without the capabilities of, I think we had a police officer on, because he said he's a detective constable, without that kind of assistance. So in lieu of the X, it has to be signature. I don't know of any jurisdiction that accepts the fingerprint as yet. There could well be, but as yet I can't put my finger, literally, I can't put my finger on any. So it's one of those 2.
Okay, great. Thank you so much, everyone, for your question. Thank you, Nadine, for sharing this wealth of knowledge.
Absolutely.
I'm sure it was greatly appreciated. The chat is buzzing, giving you thumbs up for a great presentation. Information was informative. They have learned a lot, and definitely they are desirous of, continuing on the process of learning more about the estate planning aspect of, planning ahead for your future and for the future of your loved ones. So thank you all for attending. We'll have the recording uploaded to our YouTube channel. For those who have recorded it to be sent to their emails, that will be done. And Nadine did share her information if it is that you need the actual slides, and the templates for the will and other things are available on our website. So have a good evening, a good morning, wherever you are, and thank you for being with us. And we'll be in touch for the next webinar.
Great. Thank you very much, everybody, for joining us, and take good care.